But Mr. Clement, why doesn't whether or not it's wholly collateral turn to some extent on the remedy that you're asking for? It would seem to me that one way to think about the collateralness of this is whether, when you're done with it, the claim that you want to bring in district court, you would go back to the agency and the agency would proceed. I think that in a situation in which you have the type of claim, maybe some of your removal claims with respect to the ALJ, for example, if the remedy is just give us a new ALJ, then there's a concern that what is happening by allowing citizens to go to the district court is that they're sort of superintending the agency process. Whereas you could say, and therefore you could say it's not wholly collateral in the same way as if you went over and the remedy was to terminate the agency process. So why shouldn't we be thinking about the collateral nature of this based on the remedy that you're asking for?
So two things, Justice Jackson. First of all, I think the most sort of straightforward way to think about whether it's wholly collateral is, does it turn on the facts of the particular case, or is it a claim that would be the same no matter what the facts of the particular transaction is or the particular immigration circumstances of an individual? And if it really doesn't matter on your circumstances, then I think it's wholly collateral. To your point about the remedy, though, I think that favors us, especially on the removal claim, because I think the problem is there are cases where the remedy you want is really just to have your federal job back or the Mine Safety Board order vacated. And in those situations, maybe it makes sense to say, yeah, if you're in the process, it leads to an order, and at the end of the order, you can get it vacated. That's good enough. That's a meaningful judicial remedy.
But I guess maybe I'm not so clear. I meant a remedy that does not have you returning to the agency in any respect, so that your claim is such that, you know, the core constitutional claim, this agency doesn't have power over me, you can go to the district court because if you win, then the agency is done. What I'm concerned about is the interpretation that allows you to take certain claims over to the district court and have it impact the agency, ongoing agency proceeding in a way that makes it unclear that that's what Congress intended in terms of saving 1331.
So I guess I would just amend your observation. I mean, I think you're right that if you have a remedy that says I ought to be completely immune from this agency's actions at all, that's something that does seem like it should be able to go forward in district court. But I think if you have a claim that's effectively, I shouldn't be in front of this agency at all as currently structured, that is equally a claim that doesn't belong in front of the agency. And I think, as I indicated to Justice Thomas, I think it's particularly clear when you start thinking about the right remedy for the double for-cause removal restriction here. Now, obviously, you could remedy a double for-cause removal restriction by invalidating either layer of removal. But if a court were to follow the pattern of Free Enterprise Fund, you'd get rid of the second layer of removal restrictions, and those are in 5 U.S.C. 7521.
Mr.